will be kind of leading the discussion. I just had a couple of opening comments, if you don't mind, just from a personal perspective. I certainly have always been somebody that has supported term limits to some degree wherever that discussion is. In fact, when we had our group that came together, our charter review group a few years ago, I testified before the group that I thought county commissioners should be subject to term limits. And so over the years, I think there's been and I'm just going to read a couple comments here, there's been a predisposition for term limits in the cities and counties. So I think it's way past time to at least have the conversation. And in Pinellas County, as you know, in 1995, there was actually a referendum passed over 70% in favor of term limits, and ultimately the Supreme Court took action. I'm not going to get into all the legal stuff that we currently don't have term limits. And I guess there's arguments for and against. I just think there's a time for new perspective, new ideas, new ways to implement things. And so bringing new folks through the offices that we currently occupy, I think is important. I know Jules going to talk a little bit about what different counties are doing and different options and that kind of thing. I think in the end, and we'll get more direction from Jewel, we have to kind of balance simplicity, trying to be simple so that it survives any kind of judicial challenges, but at the same time complicated enough to address the issues that we need to address. So from my perspective, and I've talked to a lot of people that consider themselves non-term limit people, but when you talk specifically about 16, 20 years, they kind of say, well, of course, that's way too long. So not everybody, but many that I've talked to. So then I talk about, well, then you do support term limits. You maybe just don't support 8 years. The 8 years is enough concept. So again, having had a lot of those conversations. The other thing that strikes me, well, anyway, my idea was that we talk a little bit about it, and I think we need 5 people to bring forward conversation or for referendum. 5 of us have to support that effort. Our residents have taken that effort themselves, and it led to what we now have, which is not term limits. So I think we really need to provide that opportunity. And so my thought was, since baseball analogies seem to be in vogue today, as we start baseball postseason, that 3 terms and you're out. So the idea would be that we have 12 years to serve, and then you step away from the dais. You are finished as a county commissioner. Some people have said, well, maybe you should be able to run for the other seat. And I suppose if you stepped away for 2 to 4 years, depending on how that seat lines up, that may be something that we can consider. But you need to be, the idea you step away from the dais, unlike in Hillsborough County where they have 8 years, but they can immediately apply for the other seat that they're eligible for. And then they go back and forth. And I just don't think that accomplishes what you're trying to do with term limits. I guess for me, we've had 2 decades since that happened, plus. We've had a lot of people challenge why we don't have it since then. We have people that say 8 years, don't ever deviate from 8 years. We have term limits, and I argue with them, well, we don't. And I thought this was a way that we could at least be responding to an overwhelming number of people nationwide, but also in our county through that referendum to do it on their behalf and leave an option for them. We'll get into some of the details, and there's transition for each of our seats that are currently holding it. But I do think that we have that opportunity today to have that discussion, to at least see if there's an appetite for this commission to do the right thing. I will tell you, we have had two groups that have come together that have looked at our charter. I don't know about the one 2 times ago, but I know the last one, the Charter Review Commission, didn't even discuss it. There was a motion to bring it on the floor for discussion. There was not a second. And it's either that the group that we assembled have independent thinking that they don't like that idea, or they simply are, many of them, a reflection of us up here that may not like the idea. But it didn't even come up for discussion, which I thought was just shameful. And I said it to some people, including my representative that I selected for that board. And so I think we owe it to our residents to have the discussion. We owe it to our residents to give them an option. I would argue that people who say 8 is enough, maybe when given an option back in 1995 for 12 years versus 8 years, there might have been an appetite for that. I don't know. But here we are today, and I think we have that opportunity, and so that's why I brought it forward. So Jewel, if you will take it over for the presentation, and then we can open up for discussion. Thank you.
Sure. Well, good morning. Hopefully I will kind of get you all through this. We'll see if I can operate this. I don't want to dwell too much on the past, but at the same time, I felt like it was important to sort of spend a little bit of time going over the past, just to kind of set the stage for where we are today and to give some context to your discussion today. So, there's about 3 pages here because we do have, a bit of a past here with some litigation that I just sort of wanted to walk through. I know this timeline starts out a little bit odd with the lawsuit being filed before you actually see the resolution being adopted. But keep in mind, prior to that July 1996 date, there was a political action committee, 8 is Enough in Pinellas, that had gathered the signatures. They'd been verified. They were, on their way to having that question placed on the ballot. So folks knew that this was moving forward prior to where you see your timeline here begin. So that lawsuit that was filed in 1996 was basically an effort to prevent the effort from moving forward. It was not successful. As you can see, in September, the county commission at that time did adopt the resolution based upon the citizen initiative to place the question on the ballot. You'll see there it was approved by voters. The circuit court back in 1999 declared the amendment constitutional and entered judgment in favor of the political action committee. And as you can see, the second DCA affirmed that ruling. What's not on your timeline here, but I did want to mention, is keep in mind that back in that 1999-2000 timeframe, the composition of the county commission was completely changed. So back in 1996, when this effort first began, we had 5 at-large county commission districts. And by the time we got to the election in 2000, we had our composition today. So 7 commissioners, 4 single-member, 3 at-large. So while this, I'll call it the dispute, the litigation was going on, the composition of the county commission completely changed, which was something that at least played into some of the arguments made in later litigation. Here's some more you can see. We went up at the time to the Supreme Court, which ultimately declared the term limits invalid. Now, the parties that took it all the way up to the Supreme Court were some of the constitutional officers. The county did participate in some of the litigation initially, but by the time that this litigation made its way to the Supreme Court, I think it was 3 of our constitutional officers remained as parties. Now, the question at the time, and we'll get to the question, I have it on a slide a little bit later, the question was a single question. So the question that was put before voters was whether all 5 of the constitutional officers and the county commissioners should be term limited to 2 term limits. So when the constitutional officers challenged it and succeeded, the entire question failed. So no term limits for any of our local officers here in Pinellas County, and that was the ruling of the Supreme Court. Commissioner Eggers referenced this. I just put it in there for factual. 2010, the CRC took it up and declined to do anything with it. I will tell you, I did pull some of the minutes from these CRCs, and that what's noted in the final report of the 2020 Charter Review Commission. It states the CRC believes that such provisions artificially limit the ability of the voters to exercise their right to choose their commissioners, and therefore no recommendations were made. So moving forward, May 2012, Broward County. Broward County had really been going through some of the litigation at the same time as Pinellas County. Theirs was more specific to county commissioners. And they're actually the one county that I did find that has a term limit of 3 terms. Most of the counties that I looked at in our cities that are here nearby have a term limit of 2 term limits. So Broward County's case went up to the Supreme Court. And what the Supreme Court did at that time is it receded from its, I put reversed up there, really, the legal term is receded. They receded from their prior holding, essentially in our case, and said, no, we feel that counties, charter counties, let me be clear, only charter counties can take this step. The Supreme Court basically said that we feel that the broad home rule powers granted to charter counties do give those counties the authority to impose term limits. So probably some of you might have been, even here and more aware. After that, we did have a lawsuit filed seeking to remove our commissioners who at that time had already served 2 or more terms. That litigation was not successful. Circuit Court ruled in favor of the county commissioners that were named in that suit, and the second DCA affirmed. You'll see there was some subsequent action trying to compel the county attorney at the time, not me, to insert the language into the charter, but that litigation also was unsuccessful. So there are no term limits here in Pinellas County. Again, as Commissioner Eggers already referenced, in 2016, the CRC discussed it and again declined to move forward with a proposal. And I think, Commissioner Long, you might have been our representative on the CRC back at that time, so perhaps you have some recollection of that. I did pull the minutes and see some of the discussion that was had, but again, there was nothing moved forward at that time. So here's the question that was on the ballot back at the time. A little odd because it doesn't read like a question, but that is the language that appeared on the ballot. And as you can see, it includes all of the local officers here, so all 5 of the constitutional officers and the county commissioners. And as you'll see there, it also specifically provides that terms of office prior to the amendment were not counted toward the 2-term term limit. So just some background information on how the charter can be amended, the Pinellas County Charter. Of course, the county commission can do it by ordinance, and as you see there, what's required is a majority vote plus one, and of course, then it goes to referendum. Now, again, referendum can be at a general or a special election. You've got some big elections coming up next year, so if you did move forward, you could easily place it on one of those elections that is already scheduled to take place. Citizen initiative is another way that it can be amended. Of course, that's what we saw happen back in the 90s that brought this issue forward the first time around. And of course, by Charter Review Commission. Your next Charter Review Commission will meet probably, I would guess, beginning in 2023 and would have access to the 2024 ballot to place any questions they may approve.
Commissioner.
Thank you.
Justice.
Thank you, Mr. Chair. Just a couple of quick questions. The citizen initiative, do you know what the numbers are? How many signatures they need, petitions for a charter?
I have the charter pulled up over there on my computer, I can tell you. I want to say that in one of the last CRCs, we changed it. I want to say we might have taken it down just a little bit. When I sit down, I can give you that information. I do have it pulled up. I know that there is a minimum percentage of, I believe it's registered voters is how the charter reads, not just citizens, but registered voters. And it also is required to be spread throughout the county. So a minimum number, I believe it reads from each district to ensure that it's not completely focused in, one part of the county.
And then the charter, you said the Charter Review Commission meets, how often? Is it 7?
They meet every 8 years,
8 years.
now. Again, that was a change that was made, I think, back in 2010. And we used to meet, the Charter Review Commission used to meet every 6 years, but a change that was made, I want to say again back in 2010, was for it to meet every 8 years so that it would coincide, that it would always coincide with a presidential ballot.
Thank you.
Commissioner Long, you had a question?
Yes, Mr. Chair. I don't know if this is a question or more of a fact for my colleagues, which is interesting that Commissioner Flowers and Commissioner Seal aren't here today. But I think we have term limits, Mr. Chair, and that's because I'm in the first year of my third term. In 8 years on this county commission, since I was initially elected, we have had 4 county commissioners that are no longer with us. And to me, that is almost an entire, that's, the majority of the county commission in 8 years are new. And with the budget the size that we have, the scope of responsibility that we have, I think it's an enormous challenge to ask a brand-new commissioner to be totally up to speed on all these issues in a short amount of time. In my opinion, we have term limits because if the voters don't like a commissioner that's in office and they don't think they're performing properly, guess what? They'll be voted out of office. So I find it somewhat interesting that, yes, you were at the Charter Review Commission and spoke vehemently about the need for term limits, and I'm curious about if you remember our conversation right after you speaking and how interesting it is that now you are past 8 years and you are running for re-election again. So it seems a little disingenuous to want to bring this forward when voters have clearly expressed their interest. Thank you.
Yeah, well, I really don't want to get into debate yet. I can debate almost everything you just said and totally disagree with all of it. But why don't you go ahead and finish I don't think there's any other questions at this time, but go ahead and finish your presentation, if you will.
Well, just a little bit of comparison, what we see around the state, and I really pulled some of the bigger counties and our 2 larger municipalities here locally, just to show you what they have in their charters. Again, Broward, like I mentioned, is the only county that I found that has 3 4-year terms. What's typical to see are 2 4-year terms. It gets described a little bit differently in different charters. Sometimes they say 2 full terms. Sometimes they say 8 years. I found one that said 6 years during 2 terms. So, you can be very specific in how you craft things. But just for some perspective, that's what we see here locally. Now, I did want to mention that I think that most of you all are aware, Hillsborough County and the city of Tampa, their charters are pretty specific as far as allowing a commissioner to serve, for instance, 2 terms in a single member district and then to run for the at-large district. Many of the other charters are silent, so I don't know how to interpret that necessarily, but I would say if you see something that says 2 consecutive terms, to me, without a provision that says you can run for those other terms, that would be a prohibition. Certainly could be something that was up for debate, but one thing I would point out is that if you do wish to move forward, I think that it would be good to have a full discussion on exactly what you would want term limits to look like, whether you would wish to allow moving from single member to at-large, whether, for instance, you might want to say, well, a term limit would be 3 terms, but you could sit out 2 years and then run for another seat. I did find that in one charter. I believe that was down in Sarasota. There are different ways that you can craft language to basically accomplish your purpose. I'll move forward to here. This again is hopefully I captured, what you were thinking. But this is sort of at least what I talked about with the chair as far as a proposal. Again, my suggestion would be that if, for instance, this is what you wanted to move forward with, that we craft language very specific to make it very clear that that's our intent. You'll see the last bullet there, I put prospective application only, but that's not altogether true because it does say that someone who has or will by the end of their term have served 3 consecutive terms may serve 1 additional. So that is not truly prospective because many of the charters that I looked at did include language. For instance, if we were to put it on next year's ballot in 2022, many of the charters that I looked at did have specific language that would say no term prior to 2022 counts towards the term limit. So that is not uncommon. I did find what I thought to be 1 or 2 charters that did apply the term limits retroactively. St. Pete's charter applied the term limits retroactively when they first came into the charter. I spoke with someone in the city attorney's office. They didn't recall having any litigation over it. But again, that was some time ago. So there's not a lot of case law on the retroactive application of term limits, but in theory, it's something that could be done. So that's really what I have to present, and I will take any questions any of you all might have.
On that the original vote back in 1995, I think you said that it allowed for, because there's always the transition. You're dealing with new folks, in that case would have had 8 years, but those that were serving, I think you said they were allowed to finish their term plus 1 more term. Did I hear that, or is that?
What the language back that was adopted by the BCC resolution in 1996 stated was, terms of office beginning before the amendment approval are not to be counted towards the term limit. So it was truly prospective only. So anybody on the commission at the time was not limited in any way.
So you would be finishing your terms plus 2 more terms.
Correct.
Okay. And what we talked about just a minute ago was serving 1 more term after the existing term is up. So my thought, and just the question is, like, if you used November 1st of next year, so there's still term left. I guess that's not prospective, that's retroactive 2 weeks for a start date. So if you were to use November 1st of that and you say you get to finish the term that you're in, plus 1 more term, comma, for a minimum of 3 terms. That kind of, it deals with transition for each of us, but also going forward, it just says it'll be 3 terms. So, and keeping in mind for anybody, if you want to consider 8 years, I'm open to considering 8 years too. I'm just saying that, our residents spoke. I know the predisposition is so far it's been to not have term limits. And talking to a number of people that are so inclined, said some term limits make sense. And so 3 terms made sense to me as long as you step away from the dais after the 3 terms and you're not continuing on. And maybe that's another discussion point that we need to have. So anyway, I have other thoughts, but I want to turn it over to others that may want to. Yes, Commissioner Justice.
Thank you, Mr. Chairman. Do you remember, because I have this vague memory that a lot of the early 90s term limit talk was focused on Congress. And did we have an initiative, a ballot initiative on term limits for Congress that got thrown out? I was trying to remember the legal cases back then.
I can't totally recall, but I will tell you in doing some research just for today's presentation, the Florida Constitution contains term limits for like governor and cabinet and some of the state offices. It did, once upon a time, include term limits for Congress and for U.S. Senate, and those have been thrown out basically under the theory that that's left to the federal government, that's not left to the state government. And I apologize, I can't speak to the circumstances under which that part of the Constitution was overruled, but I do think there was a lawsuit that led to that.
That was kind of my memory, that the courts ruled that local can't apply federal rules to the federal body. That was kind of how I remembered it as well. It's just, it's an interesting conversation, and the fact that 2 charter review boards have met and declined to move this forward to a vote is telling. We used to have a gentleman from North County that would come visit us a lot several years ago, but I haven't seen him in years. And besides one of our speakers that speaks almost every meeting, that I assume he was referring to term limits when he calls half the board illegal commissioner. I assume that's what he's talking about. He doesn't specify. But beyond that, those 2 individuals, term limits is just never comes up. No one has ever brought it up to me as far as something that we should be doing. Not saying it's not worthy of discussion, and anytime one of our commissioners has a thought we should, it's certainly worth that conversation. It's also worth noting in Pinellas County, that, as Commissioner Long noted, we have had turnover in the last 10 years on this board, significant turnover of at least 3 incumbents that were voted out of office. And on the flip side, we had a commissioner that's serving 24 years. We have constitutionals that are serving 20 years. We had a state senator who served, I think, 30 years. We had a congressman who served 40 years. So for a community that's, the cry out for term limits isn't reflected in the ballot boxes, is my initial thought. But, and then if we do take this conversation a step further, I certainly would have some thoughts on the details of the implementation.
And that is one thing, again, that I'll just reiterate. I would encourage you all to, if you do move forward, to be very specific in your thoughts on this so that we can craft language accordingly.